Hi there, this is Jonathan Ginsburg. I wanted to update you about some recent developments in the Social Security world. And as you may remember, if you take a look at the video, I did a video report back in January of 2013 where I discussed a report issued by Senator Tom Coburn of Oklahoma about the Social Security disability process. And the gist of this report was that Senator Coburn felt that too many judges were approving cases on insufficient evidence, that he and his staff did a review, and they saw that about a third of the cases were wrongfully approved, or the decisions were not based on fact, and he was taking the position that Social Security was being too fast and loose with its rules, and he made a number of recommendations that the ship get tightened up a little bit so that fewer Social Security disability cases would be approved. And in fact, as I suggested back then, a lot of these recommendations have been sort of adopted by Social Security. There was a chart that was released by Social Security that showed about 5 years ago, 63% of hearing cases at hearings were approved. In 2013, that's down to 48%. So you're looking at a 15% drop in case approvals in 5 years. And again, maybe some of that's because there are more applications, but I think part of it is that Social Security is under a lot of pressure to limit the number of approvals. As you probably know, the trust fund for disability is going to run out of money in a year or so. Congress is probably going to wait till the very last minute to shore it up. And there's a lot of pressure in Congress, both amongst Republicans and Democrats, to limit the number of approvals. There's a feeling that there's some rogue judges out there who are approving cases without really substantial evidence, and that the system is a little bit out of control. Now, I will tell you that Senator Coburn is retiring. He, unfortunately for him, has cancer, and because of the treatment, he's not been able to spend as much time in Congress, and he's decided that he doesn't want the stress of being in the Senate anymore. He is retiring. And so, again, he won't be there. The person who replaces him from Oklahoma may or may not take the same approach, but there are other Congress people who are really taking up the sword of trying to limit the entitlement programs and so forth. And just as an example, there's a representative, I believe he's from South Carolina, named Trey Gowdy. And he recently held some hearings where he basically eviscerated a Social Security judge. Now, the judge that he went after, and I'm going to try to put some of that testimony in his video here, was Judge Krafsur from Tennessee. And basically, Judge Krafsur had an approval rate of something like 99%. I'd have been in front of Judge Krafsur, a really nice guy, but with all due respect to him, his evaluation process was not very comprehensive. He approved a case really without really considering very much evidence at all. But Representative Gowdy just basically just completely destroyed him. It's really kind of uncomfortable to watch. And again, I'll put some of that in here.
Thank you, Mr. Chairman. Judge Krafsur, I'm going to read you a quote, and you tell me whether or not you know who said this, okay? 100% of the women at call centers have been abused. It's an atmosphere of abuse. Anytime we see a call center person, female, all have been abused. Do you know who said that, Judge?
I did. It was taken out of context.
Well,
sir, your microphone, can you repeat that, sir?
Yes.
He said it was taken out of context. Well, let's put that in context. Judge, did somebody testify to that at a lower level? Was that in the record?
No, sir, that was my experience.
Did you rely on a learned treatise? You made a point of saying in your opening statement how much respect you pay to the federal rules and the Constitution. Was that a learned treatise you relied upon, Judge?
No, that was my experience over 20
So you
years.
made yourself a witness even though the federal rules are very clear that judges are not witnesses. Is that what your testimony is, Judge?
That was my opinion, not anything. It was my
100% of female employees at call centers have been abused.
I didn't say that. 100% of the people that appeared before me have been abused.
And you relied on no learned treatise, no testimony at a lower level, just your innate sense of medicine?
No, that's been my experience having hearings.
Well, let me ask you about another one of your experiences, Judge. I want to read you another quote and ask you whether or not you recognize who said this, okay?
Mm-hmm.
How did your family discipline you? Did they hit you on the butt? I'm starting to do some analysis. It's starting to be when women are hit at an early age, they start developing problems in their 20s, late teens and 20s. My ex-wife told me about this. There's something in a girl that's a sexual thing. It arouses certain things. Did you say that, Judge?
Yes, I did.
Did you rely upon a learned treatise in reaching that determination?
No, I relied on...
Did you rely on something at a lower level, a hearing, a witness testified to that?
No, I relied on my experience hearing case over 20 years.
Judge, I hasten to add, because you made a point of saying in your opening statement that your first responsibility is to the Constitution and the federal rules of evidence. Are you aware that judges can't be witnesses? Are you familiar with that, Judge?
I don't consider myself a witness.
You just testified to your own personal experience. If that's not a witness, what is it?
That's a personal opinion.
Judges can't express personal opinions either. That's why we have something called experts.
So that's
Did an expert testify to that, Judge?
That's called a First Amendment right.
You're considered, so you have a First Amendment right to say whatever the hell you want in a hearing. Is that what you're saying?
No, sir.
And you can rely upon that when you're spending taxpayer money?
No, sir. But that's an isolated case.
Well, it can't be an isolated case. I just cited two.
Yeah.
And my colleagues cited others.
Yeah, you're taking isolated cases. I've had...
let's go a little broader than that, Judge. What is your reversal rate of the hearing officer? Is it in excess of 90%?
Yes, it's based upon testimony given to me.
All right, and it has to be adjudicated twice before it gets to you, right?
That's correct.
And only if it's denied does it get to you. So 90% of the time, the people under you are wrong.
No, I want to be able to cross...
Well, it has to be, or you wouldn't be reversing them. They've denied benefits, Judge, and you've reversed their denial. That means that you're hiring some really dumb people to be hearing officers because they're wrong 90% of the time.
No, sir. I want to be able to cross-examine the people from Social Security.
I'm glad you mentioned cross-examination.
Right.
I can't tell you how glad I am.
Yeah.
Because in every other court proceeding, there is someone cross-examining the witnesses, but it's not a judge. It's an attorney, and that's true in misdemeanor crimes, that's true in felony crimes, that's true in civil cases. So what I think you need, Judge, is I think you need an advocate and an attorney for the taxpayer in the hearing room. Because I don't want you cross-examining witnesses. If you really think that paddling a child leads to sexual issues, I don't want you doing the cross-examination. And if you really think that 100% of CNAs have been abused and 100% of females in call centers have been abused, I don't want you doing the cross-examination, Judge.
Sir, we wear three hats. One hat is the Social Security hat. The other hat is the claimant's hat. The other hat is the Social Security hat.
Where's the expert witness hat? You just said you were an expert witness.
We have an adversary system, and I have the right...
It's not an adversary system. There's no advocate for the taxpayer that's in the courtroom.
We have a non-adversary system, sir. It's a non-adversary system, and I have to wear three hats.
It can't be too adversarial, or you would not reverse the hearing officer 90% of the time. And some of your colleagues, 99% of the time, they reverse a hearing officer. And we mistakenly, Judge, thought it was because you were eyeballing the witnesses so you could assess credibility. But we learned from your colleague, Mr. Taylor, that that's not even true. Sir, you don't even have a hearing. You just do it on the paper.
Sir, it's not eyeballing the witness. I take testimony. I have had here, this sheet has...
And who does the cross-examination?
It has 186 ailments on it.
Who does... Well, that's your document. Mr. Cummings just exposed it. That's your document.
The attorney also provides one for me.
The attorney for whom?
For the claimant.
That's my point. There is no attorney for the taxpayer.
Good.
We're going broke. Mr. Chairman, I know I'm out of time, but I'm going to tell you a story from Spartanburg real quickly. I had a judge call me. He's apolitical. And he said, I just sentenced someone for calling under people's houses and stealing their copper. And he said, what really struck me as being unusual, Trey, is he is 100% disabled in the back. I want you to think about that, Judge, and I want you to think about one other thing, too. I went on a tour of something called a workability center, where people with special needs value work enough that they go to work every single day. And there was one man who was confined to a wheelchair, had no use of his hands or legs, but his job was to encourage his fellow employees. There is inherent value in work. And one reason your backlog may be so big is because it's so damn easy to get benefits.
Not for me, not for me. I hear every case. I see every person that's ever appeared before me. Everyone.
You reverse the hearing officer over 90% of the time, Judge.
Because the
90% of the time, the person at the first level is wrong in your judgment, and you are citing your own version of medicine. 100% of the people are abused. That if you paddle a little girl, she's going to wind up with sexual issues, despite the fact it's not in the record, Judge.
Well,
You may be a judge, but you're not God.
Well, let me explain to you. If I had this person in front of me that was down below, I can examine him on behalf of Social Security, and that would allow the claimant's rep.
Well, then why don't your colleagues have hearings? Why do they do it on the paper? If it's that important to eyeball a witness and assess credibility and cross-examine them, why are you doing it on the paper?
That's what I said in my remarks here. We need the ability to be able to have the witnesses who give any comment down below should be appear before me, so I can examine them, and they can be cross-examined by the.
I want them being cross-examined by an advocate for the taxpayer, Your Honor, with all due respect, not a judge.
Well, then you need an adversary system, which we don't have today.
Mr. Horsford.
But in any case, you've got people like Representative Gowdy who are going to be really looking out for Social Security judges who approve a very high number of cases. I think, again, it's very hard to defend 99% approval rate. Of course, it is interesting that the judges who approve 10% are not really being called to the carpet necessarily, but the ones that approve a much higher number are certainly being looked at very carefully. I know that judges really value their independence, and there's been a real pushback amongst the judges when Congress tries to intervene. So what we're seeing amongst the Social Security Administration is they are hiring new judges. A lot of them are staff attorneys, and I guess the way they're training them would be to look much more closely at the evidence and to approve fewer cases. I think we're also seeing more of a move to eliminate benefits using the continuing disability review process where there's not going to be attorneys involved. So I think that there's not as much effort to cut back on judges, but I think what they're doing is as judges retire, they're being replaced by judges that are maybe trained a little bit different to approve fewer cases, and they're using, the CDR, the continuing review process, to reduce the number of beneficiaries in the system. So there's an ongoing effort, is my big picture point here, there's an ongoing effort to reduce the number of people that are receiving Social Security disability. There's an overall general perception in Congress that too many people are on, that it's too easy to get, and that too many people are using Social Security as sort of an extended unemployment process. I think that trend is not going to change. So what that means for those of us as attorneys in this area and for you as a claimant is that good cases are still going to be approved, but you need to make sure you have good medical evidence, that your case makes sense, that there's no issues, no common sense issues that affect it, that there's no alcohol and drug issues going on, and that the medical is very, very clear. And again, this really says to me that when I'm talking to my clients early on, we talk about what to expect during the year and a half, 2 years. How do you behave yourself? What do you do if you want to try to work? And just be prepared for those things are going to come up at a hearing, because there are some judges, I will tell you, who are looking for any reason not to approve you. So you want to make sure that you don't give them that, and that they get the clear picture, that you don't make the case confusing, that it's a very clear picture about what you can and cannot do. And hopefully, again, if you are in fact disabled, that's the conclusion they will draw. So hope this has been helpful. As I said, the trend is still not favorable for claimants, but good cases are still viable, and you should pursue them if you have a good case. Any questions about this or anything else related to Social Security, I want you to feel free to contact me and let me know. I'll try to address it. Thanks a lot.